All right. We covered the original constitutional protections for rights of the accused yesterday, that Congress shall be denied the right to pass bills of attainder, ex post facto laws, and writ of habeas corpus. And we also covered the meanings of procedural and substantial due process, as well as discussing the protections you have when the police are collecting evidence against you, and that you are protected against illegal search and seizure, that you have the right to be secure in your person's papers as effects as per the Fourth Amendment. So today we're going to cover the Fifth, Sixth, and Eighth Amendments and talk about what procedural due process really looks like. So when we're talking about the Fifth Amendment, the highlight of the Fifth Amendment is the application of due process to the federal government. And it says no person shall be held to answer for a capital crime unless on a presentment of indictment by a grand jury, nor shall any person be subject for the same offense to be twice put in jeopardy, nor be compelled to be a witness against himself or deprived of life, liberty, or property without due process of law. Please do not forget that in the Fifth Amendment, what you're trying to prevent is that you have to prove you're innocent. Remember, through this whole process of rights of the accused, the government has to build a case against you. The burden of proof lies on the government, the detectives that handled your case at the police department, all the way to the federal prosecutors in the courthouse. So, Fifth Amendment, what does it mean to compel a person to be a witness against themselves? Basically, you do not have to confess. There are no forced confessions. You do not have to talk. The ACLU has a list of the responsibilities people have when they are questioned by the police, and all you are required to do is provide identification. You do not. Hold on, my phone is ringing. Okay, I'm back. It was Miss Ng. She had to ask me about what I was doing with the midterm exam. So anyhow, you don't have to tell the police anything. The police have to prove that you're guilty. They have to do the detective work. That's reiterated in Miranda versus Arizona, where the police must inform you of your right to remain silent, and you don't have to say anything, and you have the right to counsel as well. But we'll get to right to counsel with the Sixth Amendment. Grand juries. Grand jury is a body of people that review the evidence that the prosecutors have against you and then determine if there's enough evidence to really bring your case to trial. If the government hasn't collected enough evidence against you, or the evidence is weak, then the grand jury might not issue an indictment. If you don't have an indictment issued against you, then that's the end of your case. The police haven't done the detective work necessary to prove that there's a reason to have you in the position of being held in jail. A bill of indictment is an indication that the government has collected the appropriate amount of evidence to then take you to trial, where a jury can review the evidence to see if you are guilty. And then double jeopardy. This is a good one for OJ. That's what everybody talks about, is thank God OJ, it was protected by double jeopardy. So once a jury has handed down a verdict and you have been acquitted, then there is nothing that you can do. If they found evidence in your case 3 years later, they can maybe bring about perjury charges, like if you lied when you were in the witness stand or something like that, but you are not allowed to be tried for the same crime twice. So the police and the prosecutors have to get it right the first time. Now, if you are facing state charges and federal charges, that's two different situations. You can get tried at the state level courts, and then if you then, with the actions that you carried out, you violated federal law, then you could go to federal court too. Just ask Michael Vick. Michael Vick faced federal charges and he went to federal court. He also violated Virginia state laws, and he ended up in the Surrey County Court as well for his illicit dogfighting ring. Okay, now moving on to the Sixth Amendment. Sixth Amendment applies to trial. It's not just the trial, though, because there are some important aspects of the Sixth Amendment that breach pre-trial through trial. But the text, all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, and to be informed of the nature and causes of the accusation, to be confronted with the witnesses against him, to have process for obtaining witness, and to have the assistance of counsel for his defense. And the right to trial by jury shall be preserved. So trials shall be public, so the media should be able to cover it, and there should be an opportunity for the public to witness the proceedings as per the judge's determination. So the judge doesn't want the media in there, that's fine. And speedy trial. You don't want a trial to be too quick. So you want your defense lawyer to have enough time to build an adequate defense against you, to question all the witnesses, and to make sure that you're not being rushed to trial and then rushed to sentencing. But you also don't want to rot in jail while you're waiting your trial. There isn't a magic number for this. Some states, their backlogs on their court case dockets are so deep that a speedy trial just means as soon as you can make it to the court. An impartial jury. So an impartial jury would be one that doesn't have a preconceived notion or any bias about whether or not you are guilty. They're supposed to listen to the evidence and decide your guilt solely based on the evidence presented in the court. Plea bargaining. Plea bargaining is something, it's not in the Sixth Amendment, but it definitely affects the trial process. So a plea bargain is an agreement that's made between a defendant's lawyer and the prosecuting attorney, and the defendant will agree to plead guilty for a lesser charge or for, a fewer crimes or less of a sentence. So it can greatly reduce the punishment. Now, the right to counsel is in all of this. So the right to counsel is the right to have an attorney. So your attorney's job is to make sure that your trial proceedings go fairly and speedily, and that the jury is impartial. So your lawyer is responsible for picking out some of the jury, and your lawyer is responsible for making sure that that jury is fair. Plea bargaining. A lawyer, especially if you have a state-appointed defense attorney or one that's provided by the state, might push you into plea bargaining because they don't have the time to take your case to court. And that happens in particularly areas where the prosecuting, or the public defenders, the publicly provided defense attorneys are burdened with too many cases. Now, plea bargaining, there are critics to it. Critics of plea bargain believe that some criminals are able to plead guilty and then get such a reduced sentence that they're not serving the appropriate amount of time for the crime that they committed. And then other people say that plea bargaining can entice innocent people to plead guilty. And you're like, if you are innocent, why would you plead guilty? It could be because your public defender, who has too much on their plate and has too many people to defend, has convinced you that if you go to trial, you are definitely going to be found guilty. And if you go to trial, you're definitely going to get worse sentence. So some people are unfairly pressured or unduly pressured to plead guilty just so their criminal defense attorney can move on to the next case. A pro of plea bargaining is that it saves the state time and money because it can avoid a trial. So again, even though the right to counsel isn't necessarily up here, the right to counsel is important through navigating the plea bargaining process, the speedy trial, and the impartial jury. Okay. Eighth Amendment. Two things. Bail and cruel and unusual punishment. So, no excessive bail means that your bail shall be set just enough to guarantee you return to the court for your trial. So basically, you're borrowing time from the court and you're putting down money for collateral. So if you're not a non-violent crime, definitely not capital murder or a serial killer is getting bail. But say, it's grand larceny, you've stolen something out of somebody's yard, your bail set at $4,000, you pay the court $4,000, you go home, you wait till your trial, you show back up to court, and they're going to give you a part of your $4,000 back. If you skip bail, that means you don't show up to court, but you've also forfeited your money. And most of the time, people borrow the money from a bondsman to cover their bail, which means that then the bondsman's going to set out a bounty hunter to find you to get their money back. All right. Eighth Amendment also forbids cruel and unusual punishment. Most of the debate around cruel and unusual punishment centers around the use of the death penalty. Now, there have been two cases that deal with the death penalty that you might see. Furman versus Georgia, where it became clear that Georgia's death penalty was too randomly used. So there was no consistency of which crimes were getting the death penalty, and there was an overwhelming majority of the death penalty sentencing were going to black people who had been accused of a crime who were black and committed a crime against white people. So there was this racial bias to it, and there wasn't consistency across the board of who was getting the death penalty. So in Furman versus Georgia, what the Supreme Court said is that there would be a stay on executions. And a stay means you stop them until you could come back to the drawing board and get some kind of conclusive or consistent way of handing down the death penalty. So Gregg, we're a go again. Gregg versus Georgia, the Supreme Court says death penalty was acceptable if used only in extreme crimes, that you couldn't, somebody who committed burglary or aggravated assault, especially if it was a black person against a white person, that does not constitute getting the death penalty, that the death penalty needs to be like on combo crimes, like rape and murder or kidnapping and murder. It has to be something more extreme. All right, well, that is it for Rights of the Accused. Thank you for your time. Write down your notes. Bye.